The debtor does not have an absolute right to a discharge. Now, there are a couple of ways in which creditors can object. And usually it's in the form not of an objection. We think of that in legal terminology as something that's a contested matter. It's typically done through a special kind of a lawsuit called an adversary proceeding. One way is to challenge the discharge of a particular debt. And that's usually done under a theory of fraud or breach of fiduciary duty, which does include embezzlement and larceny, or willful and malicious harm to a person or property. Although willful and malicious harm to property is dischargeable in a Chapter 13. Yet another example of that super discharge in a Chapter 13. Another way is to challenge the entire discharge. And that a creditor can do, again, using an adversary proceeding. And generally speaking, the theories that are used in that kind of a challenge are that the debtor engaged in fraud on the court, hid assets, engaged in fraudulent transfers prior to filing, fraudulent transfers being transfers of assets, either to shield them from the legitimate depredations of creditors or without getting a reasonably equivalent value in exchange for the transfer. So yes, creditors can oppose a discharge, and if they are successful, the debtor gets no discharge at all. Generally speaking, if someone comes into my office and says, well, I'd like to file a bankruptcy case and here's what's been going on, if it looks like there isn't going to be a discharge on the horizon because the debtor has engaged in all sorts of malfeasance, I might say maybe our better bet would be to work something out with some pre-bankruptcy planning or maybe do negotiations. Now, most of the grounds for denying discharge are as a result of behavior that takes place after filing the bankruptcy petition. So there, if it looks like I've got a debtor that maybe is having some integrity problems, I'm going to really lean on him to say, look, you got to control your behavior once we file the bankruptcy case. But there can be a ground for not getting a discharge because of pre-petition behavior. That is behavior that you've done prior to filing the bankruptcy petition. And the obvious example in the bankruptcy code is in a Chapter 7. Section 727 is the section under which you get a Chapter 7 discharge. And one of the things that can be used to deny a discharge is if during the 1-year period immediately prior to filing the bankruptcy petition, the debtor engaged in fraudulent transfers. That is, transferred assets with the intent to hinder, delay, or defraud the creditors. There, you are not eligible to get a Chapter 7 discharge. Of course, in a situation like that, there are a couple of things that we can do. One, of course, is simply wait beyond the 1-year mark. But because of the fraudulent transfer, that's still going to create problems, say, in that Chapter 7, where the Chapter 7 trustee assigned to the case is going to seek to undo those fraudulent transfers and recover the assets for the benefit of the bankruptcy estate and ultimately for the creditors. So the better approach, and one that is captured in a Ninth Circuit Court of Appeals case called In Re Adib, is prior to filing the bankruptcy papers, undo those fraudulent transfers, get the assets back into your name, and to the extent possible, exempt them. You might lose some of them, but at least you'd be able to get a discharge, whereas if you have these fraudulent transfers and you don't undo them, you're rendered ineligible for a Chapter 7 discharge. And of course, in other chapters, creditors can object to discharges, generally speaking, because of some sort of post-petition fraud on the court, some kind of malfeasance.